Okay, our topic for today is contracts. Okay, these are governed by Article 1305 up to Article 1422 of the Civil Code. We're expecting, of course, 10 questions, okay, from October 2020 CPA board exam. Wait, I'm check ko lang kung nagro-record. Okay, let us define first contract. Under 1305, contract is a meeting of the minds between two persons whereby one binds himself with respect to other to give something or to render some service. And under Article 1159, obligation arising from contract has the force of law between the contracting parties and it must be complied with in good faith. That's why whatever be the agreement between the parties is the law between the parties. Okay, wag lang siyang contrary to law, moral, good custom, public order, and public policy. Okay, kasi ang limitation lang ng freedom of contract, okay, is under Article 1306. Kasi ang sabi diyan, the contracting parties daw may establish such stipulation, clauses, terms, and conditions as may be deemed convenient, provided they are not contrary to law, moral, good custom, public order, or public policy. That's why if the agreement between the parties is contrary to law, moral, good custom, public order, public policy, okay, wala siyang binding effect. Okay, because such agreement is void. However, if the agreement between the parties is not contrary to law, moral, good custom, public order, public policy, then the contracting parties must respect the contract. Otherwise, they can be held liable for damages for breach of contract. Okay, there is a case. This is the case of RCPI versus Court of Appeal. Meron dito nag-send class ng Telegram by using the facilities of RCPI. However, okay, the Telegram transmitted to the recipient, okay, there is additional wording not intended by the sender. May nahalo doon na nakalagay ganito, sa iyo, walang pakinabang, dumating ka dyan, wala kang padala dito kahit bulbul mo. Okay? Kaya, okay, syempre nagalit yung recipient, okay, doon sa sender. Kaya yung sender nag-file ng action for damages against RCPI. Pero one of the defense of RCPI is that they cannot be held liable for damages because this is just a private joke lang daw between the employees of RCPI. Kaya wala raw silang intention na maging integral part siya ng message. Pero ang ruling ng Supreme Court is that petitioner daw is a domestic corporation engaged in business of receiving and transmitting messages. Now, every time a person transmits a message through the facilities of the petitioner, a contract is entered into. Upon receipt of the rate or fee fix, the petitioner undertakes to transmit the message accurately. Kaya ibig sabihin, yung mga customer or client nila, every time na nagbabayad ng fee sa kanila para i-transmit yung telegram sa recipient, ang primary duty or obligation ng corporation ay i-transmit yung message accurately. Now, since the telegram transmitted is not accurate, this is a clear breach of contract. Kaya sabi pa ng Supreme Court dito, there is no question that in the case at bar, libelous matters were included in the message transmitted without the consent or knowledge of the sender. Now, there is a clear case of breach of contract by the petitioner in adding extraneous and libelous matters in the message sent to the private respondent. Okay, now ito yung example ng stipulation na null and void being contrary to moral. Okay, yung case ng Batara versus Marcos, a promise of marriage based on a carnal consideration daw is immoral. Okay, kung nare-recall niyo yung case ng Medel, sabi ko yung sa Medel, stipulation of interest of 5.5% per month or 66% per annum was declared void because these are excessive or unconscionable. Sabi ng Supreme Court dyan, that is contra bonus mores, meaning contrary to moral siya. Pero hindi siya contrary to law because there is no more usury law. Okay? Because by virtue of central bank circular nga, sinuspend na yung application ng usury law. Kaya the contracting parties are now free to stipulate as to any amount of interest. Wag lang siyang contrary to moral. Wag lang siyang too excessive or unconscionable. Kasi pag yung interest stipulation ay too excessive or unconscionable, pwede siyang i-declared null and void, not being contrary to law, but being contra bonus mores. In another case, di ba sabi ko, yung case ng BPI versus Poltan, 3% per month or 36% per annum was also declared to be excessive. Unconscionable interest din daw siya. Pero by the way, court ang magde-determine whether or not that interest is unconscionable. Okay? Excessive or unconscionable. Okay, another is example naman to na void agreement being contrary to public policy. In the case of Hiccup versus McConray, okay, stipulation exempting a carrier from liability for gross negligence is null and void. Kaya kung halimbawa, sumakay ka ng bus, tapos merong nakalagay ng stipulation sa ticket, na even if the common carrier is guilty of gross negligence, they are exempted from liability. Okay, that is null and void. Okay, because that is contrary to public policy because common carrier, by provision of law, they are bound to exercise an extraordinary diligence. Another is to encourage fraud. Kaya nga di ba sa Article 1171, responsibility arising from fraud is demandable in all kind of obligation. Any waiver of an action for future fraud is void. Kasi contrary siya sa public policy because you're encouraging the other party to commit fraud. Another is denying access to court. And yung case ng Emeterio Cuvi versus Arellano University, di ba, na ang stipulation between the student and the school is that if the student transfer to another school, this student is bound to refund to the university all monetary benefit that he received by reason of his scholarship. That is void being contrary to public policy. Okay, now let us discuss yung kinds of contract. Okay, alam mo yung kinds of contract, mukhang wala siyang kwenta pero maraming question dito sa board exam. Okay, first is kinds of contract as to formation or perfection. Pwede raw siyang consensual, pwede siyang real, or pwede siyang formal or solemn contract. Pag consensual contract, ito yung mga contract na perfected by mere consent. Kaya once na present yung essential requisite ng contract under 1318, yung consent object cost, then the contract is already perfected. However, pag real contract siya, ito naman yung mga contract na perfected lang siya upon delivery. Kasi by nature of the contract. Okay, kaya ang lumalabas na essential requisite ng contract natin, pag consensual, check nyo muna, consent object cost lang. Pero pag real contract na, kailangan ko na ng consent object cost, dagdagan mong plus delivery. Kasi without delivery, there is no perfected contract. Okay, example ng real contract is contract of comodatum, contract of simple loan or mutuum, contract of deposit. Okay, successory contract yung pledge, saka yung antichrisis. Okay, pag sinabi naman yung formal or solemn contract, these are contract that are perfected only upon execution of the form prescribed by law. Kaya ibig sabihin, pag hindi na-comply yung form prescribed by law, then the contract is null and void. Kaya ang essential requisite natin, of contract, pagdating sa formal or solemn is consent object cost plus the form. Okay, let us summarize ha. Pag consensual, kailangan ko ng COC. Pag real contract, kailangan ko ng COC plus delivery. Pero pag formal or solemn contract, kailangan ko ng COC plus execution of the form prescribed by law. Now, ano yung mga example class ng formal or solemn contract? Okay, number 1, yung donation. Under Article 748 ng Civil Code, diba, donation of movable property where the value exceed 5,000 pesos the donation as well as the acceptance must be in writing, even a private one. In Article 749 naman, donation of immovable property regardless of value, the donation as well as the acceptance must be in a public instrument, otherwise the donation is void. Now, under the law on partnership, okay, sa partnership contract, okay, ang sabi kasi doon is that whenever there is contribution ng immovable property, di ba dapat meron daw inventory ng real property signed by the partners and attached to the public instrument. Kasi failure to comply this requirement would render the contract of partnership void. Okay, makikita mo yan sa Article 1771 in relation to Article 1773. Pero by the way, yung Article 1772, hindi siya formal contract. Kasi ang sabi ng Article 1772, di ba, every contract of partnership, okay, having capital of 3,000 pesos or more must be in a public instrument and registered before the Securities and Exchange Commission. Pero take note that even if you fail to comply those public instruments, okay, there is still a valid partnership. Kasi ang purpose lang ng Article 1772 is only for licensing requirements. Okay, meaning for purpose of registration to the SEC. Kaya kung hindi nyo na-comply yung public instrument, hindi siya mare-registered, okay, before the Securities and Exchange Commission. Pero meron pa rin existing valid partnership. Kasi hindi formal contract yung Article 1772 of the Civil Code. Okay, another example is yung Article 1956. Sa simple law motuum, sabi doon, okay, no interest shall be due unless expressly stipulated in writing. Kaya halimbawa, nag-enter tayo ng loan. Okay, pinautang kita for instance ng 1 million, may agreement tayo ng 12% interest, but the interest stipulation is verbal. Then, I cannot enforce the interest because the interest stipulation is void. Because the law requires that the stipulation must be in writing. Otherwise, the interest is void. Pero ang void rito is only the interest stipulation, not the principal. Remember yung concept na okay, accessory follows the principal because the nullity of the interest does not follow the nullity of the principal obligation. Pero pag yung principal obligation yung void, of course, it follows that the accessory contract are likewise void. Another is under the law on agency, under Article 1874 ng Civil Code. Okay, sale of land or interest therein made through an agent. The authority of the agent must be in writing, otherwise the sale is void. Pero take note, what is void here is not the agency, but rather the subsequent sale. Kaya pag nagkaroon ng sale, okay, yung agent dito, even in a public instrument, but the authority of the agent is oral, and the object is real property. In that case, okay, the subsequent sale is void. Okay, now, another example. Okay, assuming I am the principal, you are the agent. I authorize you to sell my land, okay, specific parcel of land for 1 million. But the authority given is oral. If the agent subsequently sell it, okay, either public instrument, private instrument, or oral sale, lahat yun is null and void. Because the law requires that the authority of the agents must be in writing. Okay, now question, what if the authority of the agent is in writing? Later on, okay, nagkaroon ng subsequent sale in a public instrument. Okay, anong status ng sale? Valid ba siya? The answer is yes. Okay, enforceable ba? Yes. Registrable ba? Yes. Okay, next scenario. Authority is in writing, pero binenta ng agent in a private instrument. Status ng sale? Valid? Yes. Okay, second, is that enforceable? The answer is yes. Is that registrable? The answer is no. Because only public instrument may be registered. Pero since ang status ng contract is valid and enforceable, then the other party, okay, you can compel the other party to observe the forms. Kaya pwedeng i-compel dito ng other party na mag-execute ng necessary public instrument. Okay, third scenario, authority is in writing, okay, pero binenta ng oral sale. Ano yung status dito ng transaction? Valid ba? Yes. Is that enforceable? The answer is no because covered siya ng statute of fraud under Article 1402, 1403 paragraph number 2. Kasi under statute of fraud, may mga naka-enumerate doon sa 1403 paragraph 2, na nire-required ng law na kailangan i-put siya in writing. Pero ang purpose niya is not for validity but only for purpose of enforceability. Kaya kung hindi na-comply yung form prescribed by law under 1403 paragraph 2, then the status of the contract is valid but that is unenforceable. As to cost or equivalent of value of prestation, pwede raw siyang onerous. Meron siyang equivalent value of prestation tulad ng contract of sale. When the vendor deliver the object, then the buyer should pay the price with an equivalent value. Gratuitous or lucrative, wala siyang equivalent prestation. Example is in case of donation. Kasi dito ang cost or consideration is yung act of generosity lang. Pero pag remunerative, sabi dyan, the prestation is the benefit or service that had been rendered previously. Now paki-check nyo to yung remunerative. Kasi yung cost or consideration, yung past service rendered. Now, example class, you're indebted to me for 100,000. Ngayon, kinondon ko siya out of pure generosity. In that case, that is a true donation. That's why subject yan sa, donor's tax. Now, subject yan sa donor's tax dapat. Kung yung amount is covered. Assuming stranger, dati, taxable. Now, ngayon, wala nang stranger, 6%. Now, pero dapat umabot doon sa threshold amount. Paano kung halimbawa, let us assume, you're indebted to me for 1 million pesos, pero kinondon ko siya for instance, not out of pure generosity, but because of past service rendered. In that case, hindi siya subject sa donor's tax kasi walang donation yan. Pero subject yan sa income tax. Kasi nga remunerative siya. Now, another is importance or dependence of one upon another. Pwede raw siyang principal. Ito yung mga contract that can stand alone. Now, meaning, ito yung contract na hindi siya dependent upon existence of another contract. Kung accessory naman, depend upon existence of another contract. Meaning ito yung mga contract na dependent lang siya upon existence of principal obligation. Yung preparatory, sabi dyan, not consider the contract as an end by itself but as a means for entering in a future transaction or contract. Ibig sabihin, pag sinabing preparatory contract, once the contract is perfected, it's not the end but only a beginning. Kumbaga means lang siya, para mag-enter ng another contract. Now, example class ng preparatory contract, example na muna ng principal, bigyan sa principal. Example ng principal contract is a contract of sale, contract of partnership, contract of agency, contract of barter. Yung accessory naman, ito yung di ba mga contract na dependent lang siya upon existence of another contract. Example nito is contract of guarantee, contract of surety, pledge, chattel mortgage, real estate mortgage, saka antique resistance. Yung preparatory contract naman, di ba, kumbaga means lang siya para mag-enter ng another contract tulad ng contract of partnership. Di ba ang partnership contract, once na perfect siya, it's not the end but only the beginning to enter into another contract like a contract of sale, contract of barter, contract of lease. Another example is a contract of agency. Kasi di ba once the contract of agency is perfected, it's not the end. Doon pa lang magko-comment yung agent makipag-transact sa third person in the name of the principal. As to parties obligated, pwede raw siyang unilateral or pwede siyang bilateral. Pag unilateral, it only one party has obligation. Pag bilateral, edi both parties has obligation. Pwede siyang reciprocal or non-reciprocal. As to name or designation, pwede raw siyang nominate, meaning meron siyang name or designation under the law, meaning binigyan siya ng pangalan ng batas. Example ng nominate contract is contract of sale, contract of partnership, contract of agency, contract of lease. Okay. Now, contract of guarantee, contract of surety, pledge, chattel mortgage, real estate mortgage, antithesis. May mga pangalan sa batas. Pero pag sinabing in-nominate contract, ito yung mga contract na there is no name or designation under the law. Meaning wala siyang pangalan sa batas. Okay? Now, and I'm referring to the duot des, duat facias, faciot des, and the faciot facias. Pero take note, okay, yung duot des, okay, at present is no longer an in-nominate contract. Kasi recognized na yan as nominate contract under the new civil code. Tinawag na siyang contract of barter. Okay, now, pakicheck nyo maigi yung equivalent meaning niya. Katulad niyan, duot des, di ba? Duot des, duot facias, faciot des, and faciot facias. Ang equivalent meaning niyan is, I give that you may give, I give that you may do, I do that you may give, and I do that you may do. Yeah, give, do, give, saka do. Now, question, ano bang governing law natin pagdating sa in-nominate contract? Pag binasa mo yung Article 1307, ang mag-govern daw sa in-nominate contract, number 1 is stipulation ng parties. Pag walang applicable, okay, walang stipulation sa parties, number 2, yung provision ng Title 1 and Title 2 of this book sa provision ng obligation and contract. Pag wala pa rin applicable, edi doon sa most analogous nominate contract. Pag wala pa rin, edi customs of the place. In that order. Okay, next. As to reason of fulfillment, pwede raw siyang commutative or pwede siyang aleatory. Pag commutative, meron siyang real fulfillment. Equivalent value are given. These are contracts that are not depend upon chance. Example is a contract of sale. Okay? If I sell to you an object, you need to pay a price with an equivalent value and hindi siya depend upon chance. Kaya general rule, contract of sale is commutative but sometimes aleatory. Tulad ng sale of a lottery ticket. Kasi kung halimbawa, nagbenta ako sa'yo ng lottery ticket, okay, for 10 pesos lang, pero may chance of winning, okay, for 1 million. Now, in that case, that is an aleatory contract of sale. Pero kung nagbenta ako ng lottery ticket sa'yo, na falsified pala, o kaya, okay, nabola na yan 3 months ago. Okay, meaning, wala siyang chance of winning. Hindi yan aleatory contract of sale. That is a void sale. Kasi sinasabi ng okay law on sale, okay, sale of a vain hope or expectancy is void. Yung aleatory naman, okay, yung fulfillment daw niyan depend upon chance. Example nito, a classic example of course is contract of insurance. Kasi sa insurance contract, lahat ng stipulation is already okay indicated in the policy. You either sign it or you reject. Kaya nga tinawag siyang contract of okay, sorry. Yung aleatory is I'm referring to adhesion pala, sorry. Yung aleatory, nakadepend siya, di ba, upon chance. Tulad niyan, nagbabayad ka, tama na may example natin, insurance contract. Sa contract of insurance kasi, di ba nagbabayad ka ng premiums do sa policy. Okay? Ang problema, hindi ka naman mamatay-matay do sa life insurance. Di walang attached na risk. Kasi dito, magiging liable lang ang insurance company, okay, sa life insurance once the risk is attached. Kaya nakadepend dyan upon chance. Another is time of performance or fulfillment daw. Pwede raw siyang executed or executory. Pag executory, prestation are to be complied with in the future. Kumbaga sa contract of sale, wala pang nagpe-perform sa both contracting party. May possible na meron ng definite offer, meron ng acceptance na absolute. Pero wala pang nagpe-perform sa both seller and the buyer. Yung vendor hindi pa nagdi-deliver ng object at yung buyer hindi pa nagbabayad ng price. Nasa executory pa lang yan. Pero pag executed raw, prestation already complied with. Okay, meaning both parties already perform the respective obligation. Kumbaga sa contract of sale, yung vendor nag-deliver na ng object at yung buyer nagbayad na ng price. By the way, class, paki-check nyo maigi sa problem. Kasi, okay, yung statute of fraud under 1403 paragraph 2, nag-a-apply lang yan sa wholly executory contract. Kasi the moment the contract is partially executed or fully executed contract, then forget all about statute of fraud. Okay, example class. I am the seller, you're the buyer. Okay, I sell to you a parcel of land for 5 million. Okay, verbal. Okay? In-accept mo verbal din. Okay? Ngayon, meron na tayong meeting of the minds. The answer, of course, is yes. Kasi di ba ang contract of sale is a consensual contract. Perfected siya by mere consent. Pero ang problema, covered siya ng statute of fraud under Article 1403. Kasi oral sale ng real property regardless of value must be in writing, otherwise unenforceable. Kaya lumalabas dito, okay, valid yung contract between the parties, pero unenforceable siya kasi nga covered ng statute of fraud. However, if the buyer already give an earnest money of 50,000 pesos, then the contract is a perfectly valid contract. Why? Kasi hindi na mag-a-apply ang statute of fraud under 1403 paragraph 2 because these are partially executed contracts. Kasi sabi ko nga, nag-a-apply lang ang statute of fraud sa wholly executory contract. Once na yan ay partially executed or fully executed contract, wala nang application ang statute of fraud. Now, according to number of person who participated in the drafting of the contract, pwede siyang ordinary. Kaya pag sinabing ordinary, normally both parties participate in the drafting of the instrument. Pero pag sinabing contract of adhesion, okay, sabi dyan, when the terms and condition of the contract is already drafted by one party, the other party only signifies consent by signing the contract. Okay, kaya sa contract of adhesion, prepared na yung document. You either sign it or you reject. Now, kaya nga siya tinawag na contract of adhesion kasi you either adhere or not to adhere on the stipulation indicated therein. Now, example niyan is insurance contract. Sa insurance contract, the insurance company already prepared the policy. All stipulations are already indicated therein. Okay, yung policyholder, you either sign it or you reject. Kaya pag nag-sign ka, lahat ng terms doon binding sa parties. Okay, kung ayaw mo, edi wag mo siyang pirmahan. Walang perfected contract. By the way, sa contract of adhesion kasi, since only one party participate in the drafting of the instrument, okay, it will not favor the one, okay, who make, okay, the doubt or obscure word. Now, since sa insurance contract, di ba ang nag-prepared lang yan is the insurance company, contract of adhesion siya. Pag merong provision dun sa policy na doubtful, okay, or ambiguous word, it will not favor the one who caused the doubt or obscure word. Kaya normally, i-interpret siya against the insurance company, the one who draft the instrument. Kaya nga pagdating sa insurance contract, may iingat yung mga insurance company. They want to make sure that all provision, okay, in the policy are cleared and not subject to different interpretation. Kasi the moment na merong provision dyan na doubtful word or ambiguous word, automatic it will be interpreted against them. Eh di ba normally sa insurance, ang issue lang naman kasi dyan lagi is covered ba siya ng policy o hindi siya covered ng policy. Kasi once na covered siya ng policy, the insurance company are liable. Pero kung hindi siya covered ng policy, the insurance company are not liable. Eh ang problema, may provision sa policy na doubtful. Okay, ambiguous yung word. Pwede siyang interpret na covered, pwede siyang interpret na not covered. In that case, i-interpret yan na covered because it will not favor the one who caused the doubt or obscure word. Okay, now let us proceed now sa stages of contract. Meron daw tayong tatlong stages ng contract. Bali, ito yung preparasyon, okay, perfection, saka consummation. Yung preparasyon, ang other term niyan is negosyasyon, conception, or generation. These are the steps taken by the parties leading to the perfection of the contract. Kumbaga, pag ginawa nating example yung contract of sale, okay, the vendor is trying to convince the vendee to enter into a contract of sale. Maybe there is already a definite offer, pero wala pang acceptance ng buyer na absolute. O kung meron mang acceptance sa part ng buyer, naka-qualified siya and therefore it constitute counter offer. Kaya wala pang meeting of the minds as to the object and as to the cost. Pero sa perfection or birth, sabi dyan, come to a definite agreement or meeting of the minds upon the object and the cost. Kaya kung gagawin yung example nila yung contract of sale, may definite offer na, may acceptance na absolute. Kaya lumalabas, meron na silang meeting of the minds as to the object and as to the cost. Kaya lumalabas, the contract is already perfected. Pero take note, okay, nag-a-apply lang yan. Okay, ibig sabihin, pag meron ng consent object cost, the contract is already perfected. Okay, but take note that it applies only to a consensual contract. Kasi once na yan ay real contract o kaya formal or solemn contract, kahit meron kang COC or consent object sa cost, wala pa ring stage of perfection or birth. Nandun pa rin siya sa stage of preparasyon or negosyasyon. Kasi remember, in a real contract, mape-perfect lang siya upon delivery. Kaya dapat may consent object cost plus delivery. Okay, pagdating naman dun sa formal or solemn contract, kailangan ko ng consent object cost plus execution of the form prescribed by law. Kasi kahit may COC ka na, pero wala siyang in-execute na form prescribed by law, lumalabas, okay, nasa stage of preparation ka pa rin. Okay, example kunwari, contract of comodatum. Okay, sabi ko pahihiramin kita ng okay, refrigerator free of charge. Okay, for okay, 6 months. Okay, may offer na, may acceptance ng absolute, pero walang delivery ng object. Okay, in that case, nasa stage of preparation ka pa rin. Kasi para ma-perfect ang comodatum, kailangan ko ng consent object cost plus delivery. Okay? Ngayon, sa consummation naman, death or termination, the parties have performed their respective obligation. Okay? Kumbaga sa contract of sale, yung vendor nag-deliver na ng object and the buyer already paid the price. Okay, now punta tayo sa characteristic of contract. Okay, ang first characteristic ng contract, yung tinatawag nating freedom of contract. Or sometimes we call it autonomy of contract. Yan yung Article 1306, that the contracting parties may provide for stipulation, clauses, terms, and conditions as may be deemed convenient, provided not contrary to law, moral, good custom, public order, and public policy. Kaya sabi ko nga sa inyo, ang rule is sa contract, lahat pwedeng pag-usapan. Anything. Wag lang siyang contrary to law, moral, good custom, public order, and public policy. Kasi ang limitation lang ng freedom of contract, yung 1306 lang. Okay? Now, second, yung tinatawag nating doctrine of mutuality of contract. Okay? Wait lang. Wait lang. Now, okay. Yeah. Okay. Yeah. Okay. Sorry. Okay, let's go back dun sa second characteristic of contract, which is mutuality of contract. Okay, under 1308 kasi, di ba sabi dyan, contract must bind both contracting parties. Its validity or compliance cannot be left to the will of one of them. Okay? Kaya ibig sabihin, pag ang magdidictate lang ng terms ay ako o ikaw lang, then the contract is void for total absent of consent. Total absent of consent yan. Kasi biro mo magdidictate lang ng terms, ako lang o kaya ikaw. Okay? Kasi di ba ang contract is for the parties. Kailangan meron kayong meeting of the minds as to the object and as to the cost. Okay? Kaya nga di ba sa okay, contract of sale. Okay, if I am the seller, you're the buyer. Okay? I sell to you a car, pero ang agreement natin, ako lang ang magde-determine ng price even without your acceptance. Now, ang tanong, meron bang valid sale? The answer is no. Okay? Void yan. Kasi walang consent yung other party as to the price. Kailangan i-accept niya. Kaya nga, pag binasa mo yung provision sa law on sale, di ba sabi doon, the determination of the price cannot be left to either the vendor or the vendee. Kasi pag ang magpipix ng price lang is either the vendor or the vendee without acceptance of the other, then walang valid contract of sale. Now, tingnan natin to. Pag binasa mo yung 1473, sa contract of sale, the fixing of the price can never be left to the discretion of one of the contracting parties. Kaya kung magde-determine lang ng price si seller lang or si buyer without acceptance by the other, lumalabas walang valid sale. Pero sabi niya, however, if the price fixed by one of the parties accepted by the other, the sale is perfected. Yan, laging tinatanong sa board exam yan before. Kasi ang question doon sa board exam before is this. Ako yung seller, ikaw yung buyer. Okay, I sell to you, for instance, an object. Okay, ang agreement natin is that you will fix the price without my acceptance. Okay, pinix niya at 500,000. Okay, nakalagay sa problem without my acceptance, walang valid sale. Pero kung halimbawa, Phoenix nung kabilang party ng 500,000 nakalagay and accepted by the seller, lumalabas, there is a valid sale. Kasi in-accept ng other contracting party. In that case, meron ng real consent. Pero question, what if yung seller, binenta sa buyer yung object, ang agreement nila, yung third person ang magpipix ng price. Pwede ba yun? Okay, the answer is yes. Balik tayo sa general principle ha. Sabi ng 1309, the determination of the performance may be left to a third person whose decision shall not be binding until it has been made to known both contracting parties. Kaya halimbawa, yung third person dito, finix yung price at 500,000. Binding na ba siya? No, hanggat walang communication. Kailangan ma-communicate ng third person sa seller and buyer. Let us assume na na-communicate sa seller and buyer. Okay, binding na ba siya? The answer is yes. Pero what if yung third person, in-overprice pala? Okay, di ba sabi sa law on sale kasi, okay, if a third person is acting in bad faith or under mistake, then the court may fix the price. Balik naman tayo dito sa general provision sa contract. Sabi ng 1310, the determination shall not be obligatory if it is evidently inequitable. In such case, the court shall decide what is equitable under the circumstances. Kaya kung i-apply mo yan sa law on sale, pag yung third person dito, nabawa, pinix yung price kunwari nito ng 1 million, pero in-overprice niya. Okay? In-overprice ng third person. Kasi ang agreement kunwari ng seller-buyer, third person na magpipix ng price. Then the contracting parties may ask the court to fix the price. Kasi ang sabi ng provision sa law on sale, di ba? If a third person is acting in bad faith or under mistake in fixing the price, then the court may fix the price. Pero let us assume, let us modify the problem. Yung seller, binenta sa buyer yung object. Ang agreement, yung third person ang magpipix ng price. Later on, a third person refused to fix the price. Anong effect? The contract becomes inefficacious. Ineffective yung sale for lack of price. Unless, of course, yung seller and buyer subsequently fix the price. Okay, pero kung pinix nga ng third person yung price, pero yun nga, acting in bad faith or under mistake, kasi nga, in-overprice niya, then the contracting parties may ask the court to fix the price. Okay, pag sinorelate naman natin yung doctrine of mutuality of contract sa law on partnership, sabi ng Article 1690, the designation of losses and profit cannot be entrusted to one of the partners. Halimbawa, ABC, nag-form ng partnership. Ang agreement nila, ang magde-determine lang ng distribution ng profit and loss is only A, even without acceptance ni B6. Anong effect? Void yan. Okay? Kaya lumalabas as if wala silang agreement ng profit and loss, and therefore the profit and loss, okay, will be distributed based on their respective capital contribution. Pero kung halimbawa, Phoenix kunwari ni A, kunwari ha, 50%, 30%, 20%. Walang acceptance ni BC, void yun. Void agreement, kaya ang effect, i-distribute yung profit and loss based on respective capital contribution. Kasi as if wala silang agreement ng profit and loss. Pero kung halimbawa, Phoenix ni A, 50%, 30% kay B, 20% kay C, pero inaccept ni BC yung determination ni A, binding siya kasi merong real consent na. Okay? Pero question, what if ABC agree that X, a third person, will determine the distribution ng profit and loss? Pwede ba yun? Yes. Kaya halimbawa, si X, dinetermine niya na ang distribution ng profit and loss is 50, 30, 20, binding siya from the time of communication. Kaya once na-communicate yan, magiging binding kay ABC. Pero question, what if, okay, yung third person, okay, pinix niyang 50, 30, 20, pwede bang questionin ng contracting party? Yes, if that is evidently inequitable. Pero by the way, under the law on partnership kasi, merong dalawang instances wherein the partners can no longer impugn the determination of third person. And what are those? Number one, okay, when the partnership already execute the distribution ng profit and loss. Ang reason kasi dyan, mag-a-apply yung principle of estoppel. Kasi kung hindi kayo agree, bakit nyo in-execute? Kaya once na in-execute yan, okay, binding na siya. And second, when the partners fail to impugn the determination of third person within 3 months from the date of knowledge. Kaya kung na-notify kunwari si C, okay, na ang share niya is 20%, dapat questionin niya yan. Okay, before the court within 3 months daw from the date of knowledge, otherwise, binding na siya. Kaya pakitandaan niyo yung dalawang instances wherein the partners can no longer impugn the determination of third person. Okay, another characteristic of contract is yung doctrine of relativity of contract. Makikita nyo naman yan sa Article 1311. Sabi dyan, contract takes effect only between the parties, their assigned, and legal heirs. Actually, ang general rule talaga, dapat ang contract ay for the parties lang. Awa, ang contracting parties si A and B, di ang kontrata para kay A and B lang yan. Kaya kung hindi ka contracting party, umalis ka dyan. Kasi third party ka, huwag kang makialam. Pero since ang general rule sa Article 1178, diba, all rights acquired by virtue of obligation are transmissible. Kaya kung transmissible right yan, edi yung contract, hindi lang binding sa parties, they're assigned and heirs na rin. Kasi transmissible right siya. Pero once na non-transmissible right yan, it means yung contract binds only between the parties. Pero once na transmissible right yan, edi yung contract binding lang, binding na rin sa parties, assigned, and legal heirs. Kaya ibig sabihin, ang basic rule, kung ikaw ay stranger or third person, hindi ka pwedeng mag-enforce ng contract. Kasi third party ka. Okay, illustration. Okay, take the look in the case of Manila Railroad Company versus Companya Transatlantica. Okay, halimbawa itong si A and B nag-entered ng contract of carriage para i-transport yung cargo from one place to another. Tapos ito naman si BC. Halimbawa, si B for instance, wala siyang machinery or equipment para i-unload yung cargo sa point of destination, kaya nakipag-transact naman siya kay C para i-unload yung cargo sa point of destination. Ang problema, while unloading the cargo, habang ina-unload yung cargo, the cargo was damaged. Ang question is that, pwede bang mag-file si C ng action for breach of contract against A? Okay, the answer of course is no. Kasi wala namang existing contract between A and C. Kaya dapat ang i-demanda ni C ay si B. Kasi sila yung merong existing contract, but not against A. Okay, si B, pwede siya mag-file ng third-party complaint. Okay, pwede siyang mag-file ng case naman. Okay, isasama niya sa kaso si A. Okay? Pero kung magpa-file ng direct action si C kay A for breach of contract, okay, parang malabo, di ba? Kasi wala ngang existing contract between A and C. Kaya pag nag-file ka ng case, di ba, action for breach of contract, o ano yung attachment mong breach of contract, eh wala namang existing contract nga between A and C. Okay? Kaya dapat si C mag-file ng case kay B, tapos si B naman isasama niya sa case si A. Kasi ang defense niya ngayon kay C, okay, ang merong negligence, okay, ang may negligence dito, okay, ito, okay, si C. Okay? Now, kaya ibig sabihin pag, sorry. Okay, let us modify. Bali, ibig sabihin si A, pag nag-file ng case yan, okay, hindi niya pwedeng idemanda diretso si C. Baliktad yung pagkakasabi ko. Okay? Hindi siya pwedeng mag-file ng direct action kay C. Dapat ang idemanda niya dito ay si B. Kasi sila ang merong existing contract of carriage. Okay, tapos ang defense naman ni B as against A, lumalabas is ang may negligence dyan, ang proximate cause ng loss is due to the fault of C. Okay, ngayon punta tayo dito sa exception. Kaya ulitin ko ha, kung stranger ka or third party ka, ang rule is hindi ka pwedeng makialam. Okay? Sa kontrata ng contracting party. Pero meron siyang exception. Ang unang exception natin nito, when the obligation arising from contract are not transmissible by nature, okay, personal qualification is involved by stipulation or by provision of law, like agency, partnership, comodato, lumalabas, binding lang talaga siya sa party. Yung letter B is stipulation in favor of a third person. Yung tinatawag natin stipulation for outrowing. Ano may sabihin ng stipulation for outrowing? Ito yung stipulation in favor of a third person. Okay, sabi ng Article 1311 second paragraph, if a contract daw should contain some stipulation in favor of a third person, he may demand its fulfillment provided he communicated his acceptance to the obligor before its revocation. Sabi dyan, a mere incidental benefit or interest of a person is not sufficient. The contracting parties may have clearly and deliberately conferred in favor, okay, upon a third person. Pero take note para magkaroon ng tinatawag na stipulation for outrowing, kailangan merong express stipulation yung contracting parties in favor of a third person. Kasi kung incidental benefit lang daw siya, hindi raw yan sufficient. Okay? Now, tingnan natin ng example nitong stipulation for outrowing sa case ni Mandarin Villa Incorporation versus Court of Appeal. Pakatanong nyo kasi, sir, ano may mga example ng stipulation for outrowing? Okay, example ng stipulation for outrowing is insurance contract. Diba may halimbawa, yung common carrier for instance, ininsured niya yung passenger against accident. Okay? O, nagkaroon ng aksidente, pwede bang habulin dito ng passenger yung insurance company? The answer of course is yes. Kahit na walang existing contract between the passenger and the insurance company. Kasi merong stipulation yung insurance company and the common carrier comparing benefit to the passenger. Another example is credit card. Yung credit card kasi, merong stipulation, di ba, between the credit card company and the business establishment that confers benefit to the cardholder. Okay, kaya pwedeng ma-enforce ng cardholder yung existing contract between the credit card company and the business establishment. Okay, tingnan natin tong case ng Mandarin Villa. In the evening of October 19 to 1989, private respondent Claudio De Jesus, daw a practicing lawyer and a businessman, hosted a dinner for his friend at the petitioner restaurant, the Mandarin Villa Seafood Village, Green Hills, Mandaluyong City. After dinner, the waiter handed to him the bill in the amount of 2658.50. Siyempre, itong si Claudio De Jesus, being the host, siya yung magbabayad ng bill. Now, private respondent offered to pay the bill through his credit card issued by Philippine Commercial Credit Card Incorporation. Bank card. Now, this card was accepted by the waiter who immediately proceeded to the restaurant cashier for card verification. 10 minutes later, however, the waiter returned and audibly informed private respondent that his credit card had expired. Sa madaling salita, hindi tinanggap nung cashier yung credit card. Okay? Kasi daw ang naka-reflect, card expired. Pero syempre ang contention dito ni Claudio De Jesus, anong card expired? Okay, ang nakalagay doon sa credit card, yung naka-emboss na expiry date, mag-expire ng September 1990 pa. Okay, ayan, September 1990. Okay, ang expiry date. Eh, di ba kumain sila noong October 19, 1989? Kaya obvious na yung card is not yet expired. Okay? Now, sabi dito, private respondent is guests return to their table and at this juncture, Professor Lirag, another guest uttered the following remarks. Claudie, preparing to call the Jesus, may problema ba? Baka kailangan maghugas na kami ng pinggan. Okay, thereupon, private respondent left the restaurant and got his BPI express credit card from his car and offered it to pay their bill. This was accepted and honored by the cashier after verification. Petitioner and his companion left afterward. Ang problema dito, because of humiliation, di ba? Na-humiliate kasi si Claude de Jesus, kaya nag-file siya ng action for damages. Okay, against, okay, bank card. Dinimanda niya dito actually yung bank card, pero sinama niya si Mandarin Villa. Okay? Pero sabi ng trial court, okay, hindi raw liable yung credit card company. That's why the case against bank card was dismissed. Okay? But, okay, hineld niyang liable dito si Mandarin Villa Seafood Restaurant. Okay? Makyat ng Court of Appeal, affirm, and umakyat ng Supreme Court. Ang naging main issue lang before the Supreme Court is, okay, ang una kasing defense dito ni Mandarin Villa, okay, hindi raw sila pwedeng i-compelled na mag-accept ng credit card because credit card is not legal tender. Diba? Maganda sana yung argument, diba? Pangalawa, bakit daw ine-enforce dito ni Claude de Jesus yung existing contract between, okay, Mandarin Villa and Bancard? Eh, hindi naman siya contracting party dito. Okay, on the first issue, sabi ng Supreme Court kasi dito, okay, hindi na raw pwedeng erase ng Mandarin Villa that they don't accept credit card because these are not legal tender. Because during trial kasi, na-prove therein na may nakapost pala sila doon sa restaurant na credit card accepted here. Kaya na-apply yung principle of estoppel. Yung pangalawang issue, sabi naman dito ng Supreme Court, okay, this is a clear stipulation for outrowing. Kasi merong express stipulation, okay? Meron kasing stipulation between the bank card and Mandarin Villa, okay, na nagko-conferred ng benefit sa third person, which is the cardholder. Ang problema, sabi ng Supreme Court, negligence kasi dito yung Mandarin Villa. Kasi yung point of sale guidelines between bank card and the Mandarin Villa, ito dapat yung sundan nila. Okay, na point of sale guidelines. Pag ang nag-appear sa okay machine ay card expired, dapat i-check daw muna rito yung expiry date ng card. Hindi yan ginawa ng, okay, hindi to ginawa ng Mandarin Villa. Diba? In-outright deny nila. If unexpired, refer to CB, may procedure pang gagawin. If valid raw, honor up to maximum of SPL, which is the maximum credit limit. If CB has lost, do procedure to 2A to 2E. May procedure na naman kung reported loss card yan. Ngayon kung okay yan ay by reason na suspended, canceled siya, do not honor the card. Kung expired na, do not honor the card. Eh kaso unexpired pa siya kasi ang expiry date niya September 1990, pero kumain sila noong October 19, 1989. Kaya obvious that the card is not expired. Kaya since merong negligence sa part ng Mandarin Villa, then they are liable for damages. Kaya sabi ng Supreme Court dito, a cursory reading of said rule reveals that whenever the word card expired flashes on the screen of the verification machine, petitioners should check the credit card expiry date embossed okay on the card itself. If unexpired, petitioners should honor the card provided it is not invalid, cancelled, or otherwise suspended. But if expired, petitioners should not honor the card. In this case, private respondent bank card credit card has an embossed expiry date of September 1990. Clearly, it has not yet expired on October 19, 1989, when the same was wrongfully dishonored by the petitioner. Hence, petitioner did not use the reasonable care and caution which an ordinary prudent person would have used in the same situation, and as such, petitioner is guilty of negligence. That's why liable ang Mandarin Billiard. Okay, balik tayo dito sa another exception sa relativity of contract. Sabi niyan, in a contract creating real rights daw, third person who come into possession of the object of contract are bound thereby, subject to the provision of the mortgage law and the land registration law. Now, example class halimbawa, debtor ako, creditor ka. I borrow 10 million. To secure the loan, minortgage ko sa iyo yung house and lot. Kaya meron tayong dalawang contract dito. Yung contract of loan na 10 million, tapos merong real estate mortgage. Now, ang question dito is that yung debtor mortgagor ba, pwede niyang i-dispose yung property sa stranger? Okay, the answer of course is yes. In fact, kung meron may stipulation na bawal, null and void. Kasi di ba ang sabi ng batas, any stipulation prohibiting the owner to dispose the mortgage property is void. Yun nga lang, pag binenta yan for instance ng mortgagor sa third person, lumalabas, binding siya sa third person. Kasi pag nag-default or hindi nagbayad yung debtor ng kanyang obligation kay creditor upon maturity, may right yung creditor na i-foreclose yung property, whoever be the owner. Okay, kasi yung real estate mortgage, nag-create siya ng real right. Once registered siya, binding siya against the whole world. Another is creditors are protected raw in cases of contract intended to defraud them. Bawa, ako debtor, ikaw creditor, may utang ako sa iyong 1 million. Now, ang intention ko, lokohin ka. Kaya ang ginawa ko, yung mga property ko, dinodonate ko na. Pero hindi ako nag-reserve ng sufficient property para ma-cover yung obligation ko. Okay, now under the law kasi, sa rescissible contract, di ba ang sabi doon, pag nag-dispose ka ng property by gratuitous title, ano ba yung gratuitous? Donation, succession. At hindi ka raw nag-reserve ng sufficient property to pay creditors, that is a badges of fraud. Kaya ang presumption ng batas, wala kang ibang intention kung hindi lokohin ang creditor. Okay, that's why that is lumalabas, that is rescissible contract. Okay, yung letter E naman, sabi dyan, any third person who induces another to violate this contract shall be liable for damages to the other contracting party. Okay, example class Halimbawa, si Marian Rivera, meron siyang existing contract with GMA 7. 5 years contract. Okay? Ang problema si X, yung friend ni Marian, ini-induce ni X si Marian na mag-transfer ng ABS-CBN. Okay? Or mag-transfer ng another network. Okay, may existing contract pa si Marian. Pag breach ni Marian yung kanyang existing contract through the inducement of a third person, liable ngayon yun ng third person kay GMA, even though wala silang existing contract. Okay? Because of Article 1314. Sabi nga dyan, di ba? Any third person who induces another to violate this contract shall be liable for damages to the other contracting party. Okay, another characteristic of contract is the doctrine of consensuality of contract. Bali, covered yan ng Article 1315. Sabi dyan, contracts are perfected by mere consent. And from that moment now, the parties are bound not only to the fulfillment of what has been expressly stipulated, but also to all the consequences which according to their nature may be in keeping with good faith, usage, and law. Kaya ibig sabihin, ang sinasabi, contract perfected by mere consent. Okay? That is a general rule. Applicable to consensual contract. Pero may exception nga tayong dalawa, yung real contract saka formal or solemn contract. Kasi pag real contract, perfected siya upon delivery. Pag formal or solemn contract, perfected lang siya upon execution of the form prescribed by law. Okay? Now, yung 1317 naman. Pag binasa mo yung 1317, dapat i-correlate mo yan sa Article 1403, paragraph number 1, sa unenforceable contract in relation to the law on agency. Pero by the way, dalawa kasi ang covered na scenario ng 1317. Okay, una, kunwari ito, principal, agent, third person. Ang unang scenario, itong agent ay talagang totally walang authority. At pangalawa, authorized siya, pero nag-exceeded siya ng authority. Nakipag-transact sa third person in the name nito, which is the principal. Lumalabas yung contract ng agent sa third person, unenforceable siya sa principal. Kaya di ba sa loan agency, pag ang agent ay walang authority at o kaya though authorized siya, nag-exceed siya ng okay ng kanyang authority, nakipag-transact sa third person in the name of the principal. Yung contract ng agent sa third person, unenforceable sa principal. Okay? Makikita mo rin yan sa Article 1403, paragraph number 1. Okay? Yan yung first item dun sa unenforceable contract. Kaya pag binasa mo yung 1317, no one may contract in the name of another without being authorized by the latter or unless, okay, he has by law a right to represent him. A contract entered into in the name of another, meaning nakipag-transact ka nga sa third person, without authority, no authority or legal representation, or has acted beyond his power. Kaya dito meron kang authority, pero nag-act ka beyond your authority, shall be unenforceable daw, unless it is ratified expressly or impliedly by the person on whose behalf it has been executed before it is revoked by the other contracting party. Okay, now let us proceed now sa Chapter 2, Essential Requisites of Contract. Section 1, Consent. Tatlo yung essential element ng contract, di ba? Consent, object, saka cause. Under 1318, there is no contract unless the following requisites concur. Consent of the contracting parties, object certain, which is the subject matter of the contract, and number 3, cause of the obligation, which is established now. Punta tayo dun sa element ng contract. Okay, meron tayong tatlong element ng contract. Essential element ng contract. Second is yung tinatawag nating natural element. At pangatlo, yung accidental element. Pag sinabi nating essential element ng contract, these are element of contract that without which there is no valid contract. Ibig sabihin, kung wala raw ito, walang valid contract. And there are two kinds of essential element of contract. First, yung tinatawag na common essential element of contract. And second, yung tinatawag na special essential element of contract. Pag sinabi natin common essential element of contract, these are essential element of contract that are present in all kinds of contract without exception. Sabihin lahat ng kontrata meron ito, walang exception. Pero pag sinabi natin special essential element of contract, these are essential element of contract that are present only in some contract. Kaya ibig sabihin, hindi lahat ng kontrata meron ito. And I'm referring to form, okay, sa formal or solemn contract, saka delivery in case of a real contract. Okay, now ulitin ko ha, yung solemn contract, kailangan ko ng consent, object, cause plus forms. Okay, at ito yung mga formal contract na sabi ko pagdating sa simple loan or mutuum, no interest shall be due unless expressly stipulated in writing. Kaya dapat meron kayong agreement ng interest in writing. Okay, sa law on partnership naman, pag may nag-contribute ng immovable property, dapat may inventory ng real property signed by the partners and attached to the public instrument. Kasi failure to comply this requirement would render the contract of partnership void. Donation ng movable property more than 5,000 pesos, dapat yung donation sa acceptance must be in writing. Otherwise, the donation is void. Another is, okay, donation of immovable property. Regardless of value, the donation as well as the acceptance must be in a public instrument, otherwise the donation is void. Another is a loan agency, okay, sale of land or interest therein made through an agent. The authority of the agent must be in writing, otherwise the sale is void. Nakita mo yan sa Article 1874. Sa kayong mga last will and testament, di ba? Okay, yung last will and testament, either notarial or holographic will yan, you need to comply the form prescribed by law. Otherwise, you die in intestacy. Sa real contract naman, kailangan ko ng consent object cost plus delivery. Example nga, deposit, pledge, saka comodatum, saka simple loan or mutuum, as well as antithesis. Ngayon, meron tayo class na mga, okay, as to subject pattern naman, may mga kontrata daw class na, okay, yung object na is specific, like, it must be personal property or real property. Tulad ng real estate mortgage saka antithesis. Dapat real property yung object. Pagdating naman sa chattel mortgage, dapat personal property, tapos sa pledge, personal property. Okay, kailangan ba ng delivery? Okay, the answer is no. Pagdating sa mortgage. Basta't mortgage kasi dalawa yan eh. Either real estate mortgage or chattel mortgage. Required ang delivery pagdating sa pledge, saka antithesis. Ngayon, okay, may mga kontrata din daw class. Okay, by the way, para may I think may natanong before sa CPA board exam. What if nag-entered kayo ng real estate mortgage, ang object ay personal property? Okay? Now, paano yun? Merong isang case na yan na sinasabi rito is that binding yung contract between the parties. Pero void siya sa third person. Okay, because ang reason is that the parties are guilty of estoppel. Kasi alam niyo naman na pag real estate mortgage should be real property. Hindi siya movable property. Pero void siya sa third person. Pero binding between the parties kasi mag-apply ang principle of estoppel. Now, ano naman yung natural element? Pag sinabi natin natural element, ito yung element ng contract na even there is no agreement between the parties, these are presumed to exist. Kaya ibig sabihin, hindi siya kailangan pag-usapan. Kasi ang presumption ng batas, nandyan siya. And I'm referring to the warranty in a contract of sale. Di ba may tinatawag tayong warranty against eviction, saka implied warranty against hidden defects. Now, ano ba yung concept class ng eviction? Okay, simple lang ang concept ng eviction. If I am the seller, ako yung seller, ikaw yung buyer, nagbenta ako sa iyo ng house and lot. Yung seller implied is saying na ako yung may-ari ng house and lot. Kaya ililipat ko sa iyo yung ownership and possession nito. At no one will disturb possession to you. Kaya the moment na yung buyer ay na-dispossess ng third person, either by a prior right or an act imputable to the vendor, okay, the vendor is liable to the vendee for violation ng implied warranty against eviction. Pangalawa, yung tinatawag na implied warranty against hidden defect, di ba? Implied din sinasabi ng vendor sa vendee na yung binebenta niya ay free from any hidden defect or hidden encumbrances. At yan ay merchantable quality. Ano naman yung accidental element? Pag sabing accidental element ng contract, ito naman yung element ng contract na nag-exist lang siya because of agreement. Tulad ng agreement as to period, agreement ng condition, agreement ng penalty, agreement ng place of payment, and such other agreement between the parties. Kaya halimbawa, wala tayong agreement ng condition, edi walang condition. Wala tayong agreement ng period, edi walang period, ano yan? Pure obligation yan. That's why immediately demandable. Walang agreement ng penalty, edi walang penalty. Walang agreement ng interest, edi walang interest. Walang agreement ng place of payment, o sundan mo yung provision dun sa obligation. Kasi di ba ang sabi ng batas, okay, ang place of payment would be the place indicated in the obligation. Kaya kung may agreement ng place of payment, sundan mo. Pero kung wala raw agreement ng place of payment at yung object ay determinating, nasan yung object at the time of perfection? But in any other cases, the place of payment would be the domicile of the debtor. Okay, 1319. Definition ng consent. Sabi ng 1319, consent daw is manifested by the meeting of the offer and acceptance upon the thing and the cost which are to constitute the contract. The offer daw must be certain and the acceptance must be absolute. A qualified acceptance constitute counter offer. Okay, example. Okay, si A, ito si B. Okay, in-offer niya yung object kay B for 500,000. Tapos face to face sila. Okay, si B inaccept absolutely for 500,000, the contract is perfected. Pero let us modify. Paano kung halimbawa yung object natin dito, gawin natin car, tapos contract of sale siya. In-offer ni A kay B yung car for 500,000. Tapos si B, in-accept naman niya absolutely. Okay? Pero oral sale. Okay? Now, ang tanong is, the contract of sale perfected? The answer actually is yes, because contract of sale nga is consensual. Kaya perfected siya by mere consent. Kaya perfected yung contract. Pero pag ang tanong sa inyo, is the contract enforceable? Ibang usapan na yun. Kasi kung tinatanong kita, is the contract enforceable? Ay hindi yan enforceable kasi covered siya ng statute of frauds. Kasi pag binasa mo yung Article 1403 paragraph 2 nga, di ba sabi doon, sale daw ng personal property, 500 pesos and above must be in writing, otherwise unenforceable siya. Eh, since lumagpas ka ng threshold amount dito na 500 pesos, dapat i-put in writing. Pero sabi ko, kung hindi na-comply yung writing kasi oral agreement siya, then the contract is valid pero unenforceable. Pero kung may down payment na yan, edi perfectly valid. Kasi remember, nag-apply lang ang statute of fraud sa wholly executory contract. Kaya wag mong paghaluin yung question ng perfection saka yung enforceability. Kasi pag tinatanong kita ng enforceability, mag-cross-refer ka ng Article 1403, paragraph number 2 on statute of fraud. Pero kung tinatanong kita kung perfected ba siya, o alamin mo lang kung consensual yan, real ba yan, or formal contract. Kasi once na meron ng COC yan at consensual, perfected siya. Kung yan naman ay real contract, dapat may consent object cost plus delivery. At kung formal naman, kailangan may consent object cost plus execution of the form prescribed by law. Pero let us modify. Paano kung si A in-offer kay B 500,000? Tapos in-accept ni B, si B naman sabi niya, mahal, pwede bang 499? Okay, anong effect nung sinabi niyang 499? It constitute counter offer. Therefore, ang offerer sino na? Si B. Para ma-perfect siya, kailangan i-accept ni A ng 499. Pero sabi ni A, sorry, 500. 500. Counter offer na naman siya. Okay? Kaya dapat i-accept niya. Okay? Ng 500. Okay? Kaya every time na binabago, it constitute counter offer. Kaya kung halimbawa, sabi nito, di ba sabi niya, 499, ayaw nito. Okay? Sabi niya, no. Sabi niya, sige, 500. Ikaw pa rin yung offerer ngayon. Eh sabi niya, sorry, 501 na. Di lumalabas, ang offerer si A naman. It constitute counter offer ulit. Kasi every time na minamodify mo siya, magko-constitute siya as counter offer. Ngayon, punta tayo sa 1319 second paragraph naman. Sabi diyan, acceptance made by letter or telegram daw does not bind the offerer except from the time it came to his knowledge. The contract in such case is presumed to have been entered into the place where the offer daw was made. Kanina, face-to-face sila. Eh, paano kung hindi kayo face-to-face? Ibig sabihin yung negotiation is by letter or telegram, sundan mo yung 1319 second paragraph. Example, si A, gumawa siya ng letter of offer kay B. Okay, dated 6/15/2020, sinend niya on the same date. Natanggap naman ni B ng 6/18/2020. Pagdating ng 6/19/2020, gumawa siya ng letter of acceptance and it was received by A on 6/21. Na question, kailan na perfect yung contract? Under theory of manifestation. Answer is 6/19. Pero pag tinatanong kita, kailan na perfect yung contract under theory of cognition? O kaya silent yung problem? 6/21. Kasi ang sinusundan natin under the civil code is the theory of cognition. Abandon na yung theory of manifestation. Yan yung sinusundan before sa Code of Commerce. And under theory of manifestation, the contract is perfected from the time the offeree manifests his acceptance. Di ba nagkaroon siya ng manifestation of acceptance ng 6/19? Kaya na-perfect na siya ng 6/19. Pero under theory of cognition, the contract is perfected from the time the offerer has knowledge of the acceptance by the offeree. Kailan ba nagkaroon ng knowledge yung offerer ng acceptance ni B? On 6/21. That's why the contract is perfected on 6/21. Okay? Tandaan nyo pag silent yung problem, automatic theory of cognition tayo. Yan yung 1319 second paragraph. Yung sinasabi nga, acceptance made by letter or telegram does not bind the offerer except from the time it came to his knowledge. In other words, in theory of cognition, the contract is perfected from the time the offerer has knowledge of the acceptance by the offerer. Pero, okay, i-correlate na natin siya sa other article. Okay, halimbawa, 6/15/2020. Gumawa siya ng letter of offer. Natanggap ng 6/18. Pagdating ng 6/19, gumawa naman siya ng letter of acceptance, sinend, natanggap ng 6/21. Ang problema, as of 6/20, patay na pala si B. Okay, o kaya si A. Ang mag-a-apply dyan, Article 1323. At ang sinasabi ng Article 1323, okay, an offer becomes ineffective upon the death, insanity, semi-interdiction, insolvency ng either party before acceptance conveyed. Kaya pag namatay ito, o kaya ito, o kaya naman nagkaroon ng civil interdiction kay A or kay B, okay, nagkaroon ng insolvency, okay, or insanity daw, bago dumating yung 6/21, lumalabas, walang perfected contract because the offer becomes ineffective as if there is no offer. But take note, according to Justice Paras, exception daw itong insanity. Okay, why? Kasi magre-result daw ito ng isang absurd situation. Bakit siya naging absurd situation? Okay, o gawa tayo ng dalawang illustration. Okay, halimbawa, ako, matino. Ikaw ay baliw. May valid object at may valid cause. Ano yung status ng contract? Eh di valid siya, pero voidable because one contracting parties are incapable to give consent. Is voidable contract curable defect? The answer is yes. It can be cured by ratification. Okay? Baguhin natin. Ako matino, ikaw matino din. Okay? Gumawa ka ng letter of offer, tanggap mo, gumawa ka naman ng letter of acceptance. Pero bago ko matanggap ang letter of acceptance sa'yo, nabaliw ka. Anong effect? Void yan under 1323. Diba? Kasi nga, nagkaroon ng insanity. Pero, isa siyang absurd situation. Bakit? Okay? Kasi, kababaliw lang nito eh. Fresh na fresh. Kababaliw lang. Ang nangyari, naging void na. Mas defective contract pa siya. Unlike yung kanina, okay, baliw na siya from the start, voidable lang. Okay? Curable defect pa. Pero ito, okay, kababaliw lang, isipin, bago matanggap yung letter of acceptance, doon lang siya nabaliw, naging void siya because of 1323. Kaya absurd, di ba? Naging mas defective pa. Kaya, according to Justice Paras, it should be interpreted with other provision of law. That's why it should be voidable only. Okay? Pero paki-check nyo na lang yung intent ng examiner dyan, if any. Pero, by the way, basta ang ano natin dyan is, okay, sundan na lang natin yung exception, yung insanity. Kasi nga magre-result ito ng isang absurd situation. Pero kung tinanong kayo kunwari sa board exam ng true or false, nakalagay doon kunwari, okay, an offer becomes ineffective from the moment of death, insanity, okay, civil interdiction, insanity of either party before acceptance conveyed, natural true yun, di ba? Kasi kinapi lang verbatim yung 1323. Pero pag in the form of problem siya, maybe you may consider yung insanity as exception. Pero yung death, civil interdiction sa insolvency, wala siyang exception. Okay, tapos isa pa. Yung 1321, the person making the offer daw may fix the time, place, and manner of acceptance, all of which daw must be complied with. Okay, etong 1321, ito yung ibig sabihin lang yan. Pag ikaw yung offerer daw, pwede mo raw i-fix yung time, yung place, and manner of acceptance. At dapat yung kabilang party, yung offeree, i-comply lahat ito. Siyempre, ang tanong mo, what if hindi na-comply? Isa lang ang legal effect niyan, sabi ng Supreme Court. It constitute counter-offer. Kaya ibig sabihin, pag hindi na-comply ng offeree lahat ng terms of offer, okay, ang legal effect lang niya, it constitute counter-offer, kaya walang perfected contract. Now, acceptance may be expressed or implied lang. Meaning acceptance dito, pwedeng express, pwedeng oral or in writing, at ang writing pwedeng private, pwedeng public instrument, or pwedeng implied. It can be inferred from the act. Okay? Binanggit ko na sa inyo kanina yung theory of cognition saka yung theory of manifestation. Okay. Punta tayo sa Article 1323. Okay? 1324. When the offerer thou has allowed the offeree a certain period to accept, the offer may be withdrawn at any time before acceptance by communicating such withdrawal, except when the option thou is founded upon consideration as something paid or promised. Okay, example si A. Okay? In-offer niya kay B yung object na to, kunwari, for 500,000. Determinate object. Okay? Sabi naman ni B, gusto ko siya. Ang problema, wala akong available cash. Sabi naman ni A, okay, bigyan na lang kita ng 30 days to make up your mind. Sabi naman ni B, thank you. Pero ang problema, bago mag-lapse yung 30 days, after 10 days pa lang, pinuntahan ni A si B. Sabi niya, B, sorry to inform you that I am withdrawing now my offer. Because I am now changing the price from 500,000 to 550. Ang question is that, can A modify the terms of offer before the lapse of 30 days? The answer is yes. Why? Kasi wala pa namang perfected contract dito. Okay, kung contract of sale yan, walang perfected contract of sale between A and B. At wala ring option contract because wala siyang consideration of his own. Pero let us modify the problem. What if nagbayad kunwari si B ng option money na 10,000? Kung nagbayad si B ng option money na 10,000, perfected yung tinatawag na option contract. Okay? Mape-perfect yung tinatawag na option contract. May consent si A sa kasi B. May object, okay, na 30 days. At may consideration na 10,000. Kaya lumalabas, hindi pwedeng i-modify ni A ang terms of offer before the lapse of 30 days. Otherwise, he can be held liable for breach of option contract. Hindi breach of contract of sale, kung contract of sale, hindi yan breach of contract of sale, but rather breach of option contract. Okay, dalawang pinag-usapan natin kontrata dito ngayon. Yung contract of sale dito, saka yung option contract. Kasi meron siyang consideration with own. Pero, kung walang consideration with own, it means walang option contract, wala ring perfected contract of sale. Kaya pwedeng i-withdraw ni A yung kanyang offer at any time by communicating such withdrawal. Pero once na nagbigay ng consideration of his own para dun sa option, mapa-perfect yung tinatawag na option contract. Question ulit, let us modify. Paano kung halimbawa, instead na nagbayad si B kay A ng option money, nagbayad siya ng earnest money na 100,000? In that case, na-perfect yung contract of sale. Okay? Kasi yung earnest money is a proof of perfection ng contract of sale, and that is part of the contract price. Wait lang. I-check lang ako. Okay. Hindi ko pala nalagyan. Okay, let us distinguish. Anong pinagkaiba between an option money and an earnest money? Okay, first distinction, ang option money kasi, yan ay consideration for the option contract. Yung earnest money naman is a proof of perfection ng contract of sale. Pangalawa, ang option money, okay, hindi siya deductible sa contract price as a rule. Unless merong stipulation. Pero pag earnest money, okay, deductible yan sa contract price. Third distinction. Sa option money kasi, okay, meron ditong option. Okay, yung offeree. Okay? May option yung offeree. Either i-exercise niya yung option o hayaan niya mag-lapse yung option. Samantalang sa earnest money, walang may option because the contract of sale is already perfected. No one can withdraw. Kasi once nag-withdraw ka, you can be held liable for breach of contract. At di ka rin pwedeng mag-raise ng issue on statute of fraud. Kasi kung meron ng earnest money, partially executed contract. Okay? O yan yung lumalabas na distinction between an option money and an earnest money. Okay? Now, okay. Illustration. Another example. Ito naman application to sa 1319 pa rin. A offered on January 1, okay? Tapos B accepted on January 8. Mo siya ng letter of acceptance. Ang problema, okay, nagbago yung isip ni B.
Okay? He changed his mind. Okay? Gumawa siya na, sabi natin January 8, kunwari mga alas 9 ng umaga, gumawa siya ng letter of acceptance. Okay? Tapos later on, B changed his mind, gumawa naman siya ng letter revoking the acceptance. Kaya ang question ngayon dito, may dalawang scenario. Okay? Una, okay, natanggap yung letter revoking the acceptance ng January 14. Okay? Pangalawa, natanggap yung letter of revocation ng January 16. Ibig sabihin, nauna yung letter of revocation kesa sa letter of acceptance. Ang question dito, meron ba siyang meeting of the minds? May perfected contract ba? Dito, lahat ng civil law expert nag-agree, walang perfected contract. Okay? Kasi nauna pa yung letter of revocation bago dumating yung letter of acceptance. Kasi di ba under theory of cognition, mape-perfect yung contract from the time the offerer has knowledge of the acceptance by the offering. January 14 pa lang revoke na may pangalawang scenario, what if yung letter of revocation natanggap ng January 16? Isipin, nauna yung letter of acceptance, sumunod yung letter revoking the acceptance. Ang tanong, meron bang perfected contract? The answer is wala pa rin. Okay? Pero may conflicting opinion dyan. Pag binasa mo yung book ni Reyes and Puno, yes sa kanila. Pero kay Tolentino and Manresa, wala. Pero ang susundan natin yung opinion ni Tolentino and Manresa. Walang perfected contract. Kaya kay mauna umahuli yung letter revoking the acceptance, walang meeting of the minds. Pero dito kay Reyes and Puno, alamin mo kung nung nauna. Pag nauna yung letter revoking the acceptance, walang perfected contract. Pero pag nauna yung letter of acceptance, sumunod lang yung letter revoking the acceptance, merong meeting of the minds. Pero by the way, we will follow the opinion of Tolentino and Manresa. Kaya whether or not mauna umahuli yung letter revoking the acceptance, walang meeting of the minds. Okay, punta naman tayo sa Article 1325. Sabi dyan, unless it appears otherwise daw, business advertisement of thing for sale are not definite offers, but mere invitation to make an offer. Kaya kung meron mga kayo makikita sa mga business advertisement, ang house for sale, okay, location, kunwari ito, lot area, floor area, terms niya, okay, wala pa pating price, hindi yan considered as definite offer. Okay? Hindi raw siya definite offer. Invitation lang yan to make an offer. Okay? Kaya wala pang perfected contract dyan. Okay? Pero nakalagay dyan class, paki-check nyo, unless it appears otherwise. Kasi baka mamaya, naka-indicate na lahat ng terms, including the specific location ng property, pati technical description, nilagay na. Doon din yung price niya. Pwede siyang mag-fall under definite offer. But the general rule is that lahat ng mga nakikita nyo advertisement of thing for sale, hindi yan definite offer, but only an invitation to make an offer. 1326, sabi niya, advertisement for bidders are simply invitation to make proposals and the advertiser daw is not bound to accept the highest or lowest bidder unless the contrary appears. Example, kunwari, I need, sabihin ko, I need for instance 100 units of aircon. Kaya nagpa-advertise ako, invitation for bidding. Okay, maraming bidders, halimbawa si A, B, C, D, F, G. Tapos ang highest bidder si A. O ang tanong dyan, binding ba sa akin yung highest bid? No. Kasi sabi ng batas, invitation for bidding are only an invitation daw to make proposal. Ini-invite ko lang kayong lahat na mag-propose. Kaya lumalabas kayo yung mga offerer, ako yung offering. Kaya para ma-perfect siya, kailangan ng acceptance ng advertiser. Kaya hindi raw binding sa advertiser yung highest or lowest bid. Okay? Yan yung Article 1326. 1327 naman, ito yung incapacity. Paki-check nyo, 1327 incapacity. Okay, tapos yung 1330 naman, ito yung tinatawag nating vices of consent. Sabi ng 1327, the following cannot give consent to a contract. Okay, mga incapacitated person to. Number 1, unemancipated minors. Second, insane or demented person, saka deaf, mute, were unable to read and write. Pero by the way, even though the law would not know how to write, it should be construed as unable to read and write. Kasi dapat dito yung deaf mute must be illiterate. Okay? Kasi kung deaf mute ka nga, pero naintindihan mo naman yung nature ng contract,
Okay, alam mo yung cause, alam mo yung object ng contract, then that is a perfectly valid contract. Pero kung definite siya, okay, tapos illiterate nga, okay, then lumalabas, the law should protect this person. Okay? Kaya lumalabas, okay, defective contract. Annulable siya. Okay, ito naman yung 1330, yung vices of consent. Contract where consent is given through mistake, violence, intimidation, undue influence, or fraud is voidable. Kaya lumalabas pag binasa mo yung Article 1390, di ba nakalagay doon, the following contracts are voidable even there is no damage to either contracting party. Number one, when one contracting parties are incapable to give consent, and second, whose consent is vitiated by mistake, violence, intimidation, undue influence, saka fraud. Okay? Break muna tayo. Okay? Nandito yung... Okay? Break muna tayo. Okay? Di-discuss ko yung vices of consent. Ang ingay mo, Joem, ha?